Let us now talk about the nature and the scope of administrative law. In this context, nature refers to the essential qualities, characteristics, or inherent properties of administrative law. And scope refers to the subject matter, the range of activities, and the areas where administrative law is applied. As defined in the Wade and Forsyth textbook, administrative law is the law relating to the control of governmental power. The government is also referred to as the state. We can say that administrative law addresses some important questions about the power of the state. What are the powers that the state can exercise? What are the limits on such powers? What are the procedures to be followed when exercising these powers? What are the safeguards to ensure that the power is exercised within the limits? And what are the remedies available against the abuse of any powers by the state? Administrative law is a part of public law because it deals with the relationship between the people and the government. Here, people means both natural and legal persons. Coming to the nature of administrative law, that is its main characteristics, it is a regulatory framework because it regulates government authorities to prevent the misuse of power. It is dynamic because it evolves or changes with societal needs and technological advancements. For example, with artificial intelligence becoming an intrinsic part of our daily life, our laws, including administrative law, has to evolve to deal with newer situations. It intersects with constitutional law because it provides mechanisms to implement constitutional mandates or constitutional guarantees like the right to equality under Article 14 and the right to life under Article 21. It emphasizes the principles of fairness by ensuring that the state adheres to natural justice principles like the right to a fair hearing and the absence of bias. And it enforces the rule of law by mandating that the authorities should adhere to the applicable laws both in letter and spirit. It ensures fairness, accountability, and reduces or removes arbitrariness from their actions. Moving on to the scope of administrative law. Scope means the areas or the situations where administrative law is applied. Administrative law provides control over administrative actions by ensuring judicial review if required. It is applicable to delegated legislation to ensure that the rules and regulations framed by administrative authorities are within the powers delegated to them by the empowering statutes. For example, the Income Tax Act is the empowering statute that delegates some legislative powers to the Income Tax Department to make rules or issue orders. Here, administrative law is used to ensure that the Income Tax Department does not exceed the powers given to it by the Income Tax Act. Administrative law is applicable to quasi-judicial functions where authorities resolve disputes without being full-fledged courts and perform other activities such as determining rights and levying penalties which appear to be judicial functions. It is applicable to administrative discretion, which is the flexibility given to authorities to make decisions within some legal limits. It is applicable to public corporations to ensure oversight of the public sector undertakings and statutory corporations. It is applicable to tribunals and other adjudication, where tribunals like the Central Administrative Tribunal resolve service-related disputes of government employees. It is used wherever a public interest has to be protected and accountability is to be ensured. Administrative law addresses the government's liability in contracts, torts, and other legal matters. It ensures some control mechanisms so that the administrative actions are subject to judicial, parliamentary, and procedural controls. And it is also applicable to emerging areas because administrative law adapts to address contemporary challenges like environmental regulation, digital governance, and AI technologies. To summarize, administrative law has a significant scope because it is applicable on almost all the administrative activities conducted by the state, including the creation, the powers, the procedures, and the limitations of administrative bodies.